Hello, everyone. Thanks to our over 500 participants who are joining us today for this conversation with the former prosecutor of the International Criminal Court, Fatou Bensouda. My name is Milena Stereo, and I'm the Managing Director at the Public International Law and Policy Group, and also the Charles R. Emmerich Jr., Calfee, Halter, and Griswold Professor of Law at Cleveland State University's Cleveland Marshall College of Law. I will be moderating today's roundtable, and I'm honored to be guiding the conversation with Prosecutor Bensouda. The Public International Law and Policy Group is a global pro bono law firm providing free legal assistance to parties involved in peace negotiations, drafting post-conflict constitutions, war crime prosecution, transitional justice, and human rights documentation. In the past months, our team has been fostering the development of a thought leadership initiative. This initiative focuses on a range of topics, from prominent international law issues to pressing global conflicts. Through organizing periodic roundtables, our aim is to share expertise and reflections from our work on peace negotiations, post-conflict constitution drafting, and war crimes prosecution. In today's event, I have the honor and the privilege to interview the former prosecutor to the International Criminal Court, Fatou Bensouda. Fatou Bensouda was the second ICC prosecutor from June of 2012 to June of 2021. She had previously held the position of ICC Deputy Prosecutor, having been elected with an overwhelming majority by the Assembly of State Parties in 2004. Prior to her work at the International Criminal Court, Fatou Bensouda worked as legal advisor and trial attorney at the International Criminal Tribunal for Rwanda. She has also held numerous high-ranking positions in the Gambia, including Attorney General and Minister of Justice, in which capacity she served as chief legal advisor to the President and Cabinet of the Republic of the Gambia. She has also taken part in negotiations on the Treaty for ECOWAS, the West African Parliament, and the ECOWAS Tribunal, as well as been a delegate to several United Nations conferences related to crime prevention, human rights, and the Preparatory Commission for the ICC. At the ICC, Prosecutor Bensouda initiated 13 new preliminary examinations and 7 investigations. She concluded a total of 14 preliminary examinations. Prosecutor Bensouda also reached notable convictions during her tenure, including that of the former Ugandan child soldier turned rebel, Commander Dominic Ongwen, former militia leader Bosco Ntaganda over atrocities in Eastern Democratic Republic of Congo, and Ahmad al-Mahdi for the destruction of culturally protected properties in Mali. During our conversation, we will talk about Prosecutor Bensouda's career leading up to the ICC, her legacy at the ICC, as well as her current work and the road ahead for international criminal prosecutions. The conversation will be 60 minutes long. Today's event will be recorded and subsequently posted to our website. We ask that you please submit any questions you have for Prosecutor Bensouda using the Q&A function, and we will do our best to answer your questions at the end of this event. Welcome, Prosecutor Bensouda, and thank you for agreeing to participate in today's panel. It is truly a pleasure to see you, albeit virtually.
Thank you very much, Milena. I'm really very happy to have this opportunity to be here virtually and to have a conversation with you.
Excellent. So let's begin our discussion. If I might ask the following question, what led up to you becoming the main, chief prosecutor at the ICC? How did, your career unfold, and how did it lead up to that point?
Thank you very much for that. I first of all want to underline my passion for justice. And as it evolved, it became my passion for criminal justice and international criminal justice eventually. From a very young age, this was something that I was really very passionate about. And I always talk about this anecdote when I was even in the Gambia in high school, how I just used to enjoy wandering into the courthouse to watch proceedings, to watch criminal cases being held. And of course, sometimes they will shoo us away because I would go with a few other friends. And but this has stuck with me throughout my school days and throughout the time that I went to complete my studies. I was focused on law. I thought this was where I really wanted to be, what I wanted to do. And as time went on, of course, this passion did not diminish. And eventually, when I graduated and came back to the Gambia, I went to work for the Ministry of Justice and as a prosecutor. So of course, I did have other responsibilities, but I was mainly focused in the criminal division. And after a few years serving there, I was appointed for the first time. This position was created, actually. I was appointed as the Deputy Director of Public Prosecutions. But as you know, this was after several years. I had served as a public prosecutor, a state counsel, senior state counsel, principal state counsel, and then as Deputy Director of Public Prosecutors, sometimes acting as the Director of Public Prosecutions. And when I left the ministry after when I served as Attorney General and left the ministry, I also opened my chambers. And of course, I was not prosecuting, but I did some defense work. And then eventually I left the Gambia to join the International Criminal Tribunal for Rwanda. And I can tell you that nothing prepared me for what I was about to do, what I was about to engage in. I mean, the scope, the nature of the offenses, what you had to deal with, the number of victims, the number of perpetrators. And I always say, maybe you will agree, you will not, that it's like international criminal justice just kind of sucks you in. You know, once you started, because when I was leaving the Gambia, I said that I was going away maybe for 2 years and come back. But I just came back after 20 years. 20 years. So you can imagine. It was whilst I was at the ICTR that this position as deputy prosecutor was advertised. And I was encouraged by friends to apply for that, which I did. And you know, the rest is history. I was eventually elected, as you know, by an overwhelming majority. And I served about 8 years when my predecessor's term ended, and I went in as to also get elected as prosecutor of the ICC since 2012. As you have said, I just completed this mandate, my term, in June of last year. So,
and if I might follow up on the ICTR, the Rwanda Tribunal, compared to the ICC, if you reflect back now, what are some main differences between being the prosecutor at the ICTR and being the prosecutor at the ICC? I'm sure you were well prepared for the position at the ICC, but I'm sure it was also very different. So what are some main differences between the two different tribunals? Well, Prosecutor Bensouda's connection seems to be frozen. Allow us just a few minutes to see if we can work this out.
Hello?
We have you back.
Yes, I was talking about this yesterday. We're having so much problems with, but I'm really sorry. I was
No, of course, not a problem at all. We
struggling.
understand. We understand.
Yeah,
Yes. So
I
we
mean,
were just to pick up, we were talking about the difference between being prosecutor at the ICTR and then being prosecutor at the ICC.
yes. I mean, first and foremost, of course, my responsibilities at the ICC were much greater because I was leading the office. In the ICTR, I did serve as legal advisor and then, of course, did some trial work, but then rose to senior legal advisor before I left to join the ICC. And again, if you look at my responsibilities there, I was supposed to be, very much in court and taking cases is different from when you run the office and you have several trial lawyers, senior trial lawyers, and other staff members working under you and waiting for your instructions and directions to carry out. So first, that is different. But as you know, with the ICTR, this is an institution that was set up by the United Nations, and had jurisdiction over a limited area for a limited period of time. When it comes to the ICC, as you all know, Rome Statute established the ICC. It was a treaty-based, it's a treaty-based organization, and the jurisdiction is, of course, much, much, much broader than what we did at the ICTR. It could potentially have universal jurisdiction if really you take a situation where crimes are committed on the territory of a state party, even involving non-state actors, non-state parties. So the jurisdiction of the ICCR can be practiced in every state party where these crimes have taken place and where they are not investigating and prosecuting. So already it's a big difference. It's a huge difference between the two institutions. And one has to recognize this right away, immediately. And even though the crimes that we were investigating and prosecuting in the ICTR are more or less the same as what we are doing at the ICC, but obviously the scope is very, very, very different. Scope is very different. And of course, again, I repeat that my responsibilities at the ICC were much, much greater than when I served at the ICTR.
Yes, definitely. Now, my next question has to do then with your first few years at the ICC. Once you were elected prosecutor, the court was still relatively young, had only reached one conviction by then. What were your immediate priorities once you took over as chief prosecutor?
Again, I always like to mention, to say that it's really quite a privilege to have had the opportunity to serve the ICC, both as a deputy prosecutor and later on as prosecutor of the court. So this is really a privilege for me. But when you look at the responsibilities at the ICC and what the Office of the Prosecutor had to do, still has to do, the responsibilities are huge. And the jurisdiction is much, much, much broader than what you would be faced with in any of these ad hoc tribunals. So immediately, one has to recognize the fact that you have to have the competent staff in place. You have to have the competent staff in place, committed staff, who would be able to carry out this very, sometimes even difficult tasks. So that has to be in place. You have to make sure that there is training for this staff. Those of them who come, maybe they needed training in particular areas. This had to be done. And I also recognized from the very beginning that there were certain thematic issues that are critically important for the court and for the court to set examples, such as sexual and gender-based crimes. I thought this was critically important, such as crimes against children. I thought that this was also very, very important that we should highlight and see what we can do to improve the investigation and prosecution of these crimes, to have the trained staff for them. And from the very beginning, when we start, right up to appeals and even reparations. So I needed to focus on that. But also, I said to myself that we needed to build an office with excellent office culture, that people needed to look when people are coming to the ICC, when they're coming to work, they should be happy to be coming, not when they're leaving the office. So I immediately, as soon as I took office as prosecutor, I formed a group that was called the Working Climate Group, I called it. And then I set up this task force that was to interview all staff, and everybody was free to go and speak to them and think what is going wrong and how things can be made better, etc. So this I did immediately, and I could go at length to explain what happened. But in the end, eventually, what I really wanted was this group to come out with a recommendation to me and to the senior staff, my deputy, Mr. James Stewart, to come with recommendations as to what we can do better to improve the atmosphere, the working atmosphere in the office. So this was also another priority for me. And then I introduced what is known as the core values. Core values of the office, so that the staff of the office of the prosecutor could be seen with very high moral standards, could be respected, could be placed, and could be accepted to be able to do the work that they're supposed to do. And if you go around the office at the time, maybe it's no longer there, but you'll see the core values of the office: devotion, integrity, and respect. I thought that this was particularly important, that we, as staff of the office of the prosecutor, should have these values before we even start to engage with the outside world. So this was done, and I made sure that staff were trained in this with these core values. And it started with myself and my deputy and the senior staff, going way down, so that in the end it was critically important for us to know how we interact with the outside world, how we interact with the victims, with the NGOs, with civil society, with everybody who is interested, who's the court watchers, all of those, with states parties. We needed to have this relationship in which the office can be trusted. People will have confidence in the office that we are doing what we are supposed to do, we are doing the right thing.
Thank you. Now, you already touched upon this, but one of the things that you also prioritized as prosecutor was the prosecution of sexual and gender-based crimes. And as you said, this focus on women and children as victims of conflict, and the impact of conflict of women and children and support to victims. Yes. How do you think these priorities influenced your work as prosecutor?
I think it has influenced my work a great deal as prosecutor. As I said, I was coming to the ICC with this belief, with this passion that more can be done on issues of sexual and gender-based crimes, that we really should pull it up and put it at the forefront. I'm not saying that other crimes are not important. Of course they are very important. But this particular kinds of crimes, this victimization, unfortunately, I do not think was receiving the attention that it deserved. And I saw my position as prosecutor of the ICC as an opportunity to be able to do more. And I knew that, looking at the Rome Statute, you know it as well as I do, that there are immense opportunities in the Rome Statute for one to be able to do much more than what was already being done. So I set about to doing just that for the office. And as you know, as early as 2014, I had come out with a policy on sexual and gender-based crimes. I launched this policy as early as 2014. And what I wanted to ensure was that we know at the office how to treat these offenses, that we prioritize the offenses, especially wherever we have the evidence in any of the conflicts that we were looking at, that we were going to also look at those crimes and not to explain it away. I have seen that before, that we cannot do this because I wanted it to be at the forefront. So I gave it that attention. I made sure that we undergo the necessary training for my staff. All of my staff who were involved in the investigations and prosecutions of these crimes, we made sure that there was training. We invited experts to the office to come and talk to staff, to have training sessions with staff. And we even allowed staff to go outside to also have. And when I was doing the policy, I made sure that I had as much consultation as possible with NGOs, with academia, with the states parties, with all civil society, everyone that was really interested in this area, we engaged with them. And we had roundtable meetings. Eventually, I think when the policy came out, it was a very comprehensive and it was well received because it really, we did a lot of consultations before that. And then I made sure from then on, even before, but from then on at least, I made sure that wherever we are investigating in any particular situation, that we have to look into those crimes and to charge them as long as the evidence is there for us to charge. And of course, the landmark cases like Boston Taganda and Dominic Ongwen and others are those some that I think you know about. So I do think that it has really informed a lot my time at the ICC. And one hope that I also had about coming out with the policy was that, of course, one is to give clarity, that this is how we're going to handle it. But also I thought that national jurisdictions would also be able to learn, or at least take the experience of the ICC in handling their own domestic proceedings.
Thank you. Now you were reading my mind because I was about to ask you about the Almaty and Taganda Ongwen cases. These were some of your noteworthy, victories, if I might say, at the ICC. What are some of the major achievements, if you will, through these cases, these convictions? How do you think these cases will impact the development of international criminal law and future cases and future courts?
I think in the first instance, I will talk about the Taganda case. I think this is a case that I believe is really a major contribution to international criminal law today. After having charged Boston Taganda with crimes of sexual violence of victims in his own group. If you look at the status of international criminal justice today, before Boston Taganda, it was always charges brought against the opposing group. I mean, victims, the charges were made for attacks against victims of the opposing group. And then we ask ourselves, so who's protecting those of his own group? Because we know when you investigate these crimes, you know that there are within your group children and women who are victimized, who are turned into sex slaves, who are used as, in the most terrible ways with these sexual and gender-based crimes, but who protects them. So we decided to do that, and we decided to push the envelope for that. And as you have seen, Boston Taganda has been convicted of that. And today, this, I think, is a major contribution to international criminal justice today. And then you look at also Dominic Ongwen. I know the appeal is on, and maybe what I can say is limited. But then you saw that we brought charges. We brought charges in the Boston Taganda case. We charged for rape of women, but also of men. in the Boston Taganda case, in the Dominic Ongwen case. We will see what what the appeal chamber will decide. But I believe that that also is going to be another contribution that my office has made to international criminal law and international criminal justice. You mentioned the Al Mahdi case. I can tell you today that there was a lot of debate at the office regarding the charging of the crimes of protection of cultural heritage. And of course, the office was criticized, if you remember, that we are not looking at the blood crimes, we are not looking at rapes, etc., but we are only focusing on. But I thought, and I shared this with my office, and under my leadership, we decided to go for this offense, because you know that this is becoming rampant. Now, in all the conflicts that we have all over the world, they're destroying cultural heritage. This is destroying the identity of a group, of a community. If you look at the destructions of the mausoleum in Timbuktu, it was not only affecting that particular region, it affected the continent of Africa, it affected the world. It's a world cultural heritage, for crying out loud. So this was really something that I thought that we needed. As long as the statute is allowing us to do that, we have jurisdiction, we are not overreaching, we could charge for these crimes. I wanted us to do that, to go forward with it. And as you know, you've seen Al-Mahdi pleaded guilty to those charges and was convicted and sentenced for them. And reparation has also taken place. So I think that too is another contribution which is not insignificant.
Now let's turn to the topic of preliminary examinations and investigations. You opened a number of preliminary examinations during your tenure. How did you go about choosing which cases to pursue? And I know this is a very sensitive topic, and I know this is a difficult question, but how did you, whatever you can share with us, how did you go about deciding which situations and which cases to investigate?
Maybe I will right away just refer to our case prioritization and case selection and prioritization policy. I have tried with my team to explain as much as possible, how the office was thinking in choosing these cases, in selecting these cases, and in deciding what cases are moving forward and whatnot. Because with respect to preliminary examination, I'm sure you will observe, the ICC is not a panacea. So the ICC cannot take every case. It's not even meant to do that. But I think those cases that are really very, very serious, that are grave enough to warrant the intervention of the ICC, because perhaps of the nature of the crimes, because of the scope of the crimes, because of the impact the crimes may have on the region, on the continent, even in the world. All of those are considerations. And of course, the consideration of interests of justice, all of them are considerations that we took into account when selecting a case and what to move forward. As you said, there were criticisms that some cases took too long before we come to a decision, either way, whether to open investigations or not to open investigations. But I believe that one cannot forget the fact that ICC is not a court of first instance. It is a court of last resort. And this means that we really must give the opportunity to the domestic jurisdiction to also be able to see if they can investigate and prosecute, because it is when they don't have the political will or they don't have the capacity to do that, that the ICC, where we have jurisdiction, would come in. And these are balancing acts that one has to take during preliminary examinations. And this is what really guided my office, myself, and every decision that was taken was because we have looked at the case, we have been able to study and analyze the criteria that is needed and come to a conclusion that this case must go forward, or really it cannot go forward, may sometimes even at this stage. Sometimes we defer when we say we would go forward. And this is how things were decided. It was never, and my office, everybody knew in my office that no decision would be taken based on political considerations. For me, that was a non-consideration in all the decisions that I have made. It was never for a political reason, but for the fact that we had a criteria, we had a few criteria that we had to look at. And also, once the case, once we close the preliminary examinations and we open investigations, also we really select based on how quickly we are able to get the evidence together and how we're able to present it before the judges. What are the cases that are nearing the judicial process? And sometimes you find out that as time goes on, as the cases evolve, some cases which were even started before for investigations get overtaken by others because of the circumstances on the ground. And in the end, people will always say that you did this because of that. All considerations would be made except the fact that we were moving based strictly on the Rome Statute, the legal criteria that we have, and also in the interest of justice.
Yeah, I definitely think it's very easy to criticize, right, in those complex situations. But actually, that leads me to my next question, which is that during your last few years as chief prosecutor, the court faced a number of challenges, including lack of state cooperation, criticism towards various operations of the court, and then even sanctions, as you and I discussed in our preliminary chat. You went through all these challenges with such a remarkable calmness and persistence. So, how did you do it? And then also, what do you think what do you think are some of the main challenges that the court faces going forward?
I mean, the work of the court is always, how do we put it? It generates a lot of people analyzing it, people talking about it, those criticizing, those supporting it. And I think it is the very nature of the work that we do. So this, throughout my term and even as deputy prosecutor, these are issues that you have to face. And depending on who you're investigating or not investigating, there is always bound to come, some criticism or people discussing the work that the ICC was doing. And that is why I had always said that it was critically important that amongst the considerations that we had in deciding on any particular case, politics should not be part of that. It's such a slippery slope, and it's not good for the court. And I think my staff and those of us who were dealing with know that this is how we conducted. There was no agenda, really, apart from ensuring that we did our work strictly in accordance with the law. Of course, I'm not saying that one should be completely insensitive. In the situations that we investigate and prosecute, it's full of, it's in highly politically charged situations. You cannot avoid that. This is just the reality. What I'm saying is that we should not take decisions based on politics. Of course, we're aware that the situation is highly politically charged. So this is how I try to have that balance between doing our work and at the same time being sensitive to what was going on around us, but not being influenced by us. Perhaps that is the, and of course you will see, as we saw, it created pushback. I mean, there was a lot of pushback, and I saw in the end that depending on where we were, wherever we would go, as long as it is not in favor of certain people, they would push back on the court. You've seen what we went through during the Kenya cases, for instance. During the al-Bashir case, you see this accusation of the Africa bias from Africa. And I have been sort of indicted by Africans that I am turning my back against Africa because I have been bought by the West. So these are things that, I mean, for me, my conscience always remains clear, always, because I know that I'm just doing my work in accordance with the law and the evidence that I have before me. So there was that very tough pushback from the African continent. You know about that. There was even the threat of a mass withdrawal from the ICC, because I was expected as the African prosecutor not to prosecute the cases I found there, not to prosecute the Kenya cases, not to prosecute al-Bashir, because I'm an African. Of course, that I have said from the time I took office that I come from Africa, I come from the Gambia, but I am a prosecutor for over 100 states. And this is how I conducted my business throughout. So when it also came to going outside of Africa, you saw the pushback that we also got from Russia regarding the Georgia case. We had that also regarding Ukraine. We had that pushback. And finally, when we opened the Afghanistan case, you know that it created a whole lot of controversy and pushback and trying to dissuade the ICC from moving forward, or the Office of the Prosecutor from moving forward. And but to me, what was critically important was with regards to whether we had jurisdiction, whether that jurisdiction was clear to everyone. And this is a matter that you saw the when it went for I mean, when we had all these invitations for people to come and argue regarding you saw what happened. You saw in the end what was decided, and the fact that I was asked, or I was authorized to go on with my investigation. So for me, I was not doing this with any particular agenda in mind. Of course, the other very hot topic was the Palestinian case. That was another one. And I think, as you know, to a very large extent, it was these two cases, Afghanistan and Palestine, that probably led, well, not probably, that led to the sanctions. I think it was clear. But for me, I had to do my job. And I had to do my job without fear or favor. And as long as I was able to justify legally, I was not overreaching. I was acting within the legal framework. I had the evidence to move forward with this. I did. And as it landed me in trouble, as you saw, with respect to the sanctions that were imposed on me, that were imposed on another colleague, Pakiso Mochechoko, and you recall the executive order that was made against. But I believe here I just want to take a break and just express my gratitude for the tremendous support that I have received, and the office has received, and the court has received all round, including, of course, yourselves, for fighting to ensure that it is unjustified that the prosecutor of the ICC should be targeted, should be sanctioned for doing her work. I think that was a red line. And I am so glad that when the Biden administration came, they recognized this, and immediately those sanctions were lifted. And I'm not saying I'm glad because it's me. No, I'm saying that because it's the prosecutor of the ICC that was sanctioned. This cannot happen anywhere. And I have repeatedly said this to the Assembly of States Parties, to different states, to NGOs, that this is a red line that has been crossed and it should not be allowed to stay this way, because it's the prosecutor, it's the office of the prosecutor that has been sanctioned, and this is totally wrong.
Well, as we say, you're definitely preaching to the choir on this issue of sanctions. We're obviously very glad that the Biden administration has reversed that.
Yeah.
The elephant in the room today is the Russian invasion of Ukraine. One of the questions that came in, and I think this is an excellent question, has to do with the crime of aggression. In the context of the Russian invasion of Ukraine, does this prove in some ways that the activation of the court's jurisdiction over the crime of aggression needs to be amended? You know, if you had a magic wand and you could change the Rome Statute about the crime of aggression, would you change it? And also, how about the power of the Security Council? We see in this situation that the Security Council is paralyzed in terms of referring a case. So if you could change things regarding the crime of aggression, regarding the Security Council role, how would you change them?
Well, I mean, I have to be very careful here with respect to this ongoing conflict and what I can say. First and foremost, I recognize the fact that my successor has issued a statement with regard to the invasion, the Russian invasion of Ukraine. Because if you recall, I believe it was in 2015, if I'm not mistaken, there was this declaration made by Ukraine accepting ICC's jurisdiction. And that declaration, if I recall, had no end date. So I do believe that ICC should have something to say with regards to that. With the crime of aggression, perhaps what I would first of all highlight is the fact that neither Russia nor Ukraine has ratified. None of them. So immediately it becomes it's a jurisdictional problem. It's a jurisdictional setback, which I don't think, in the absence of those ratifications, much could be done. So without further saying much further about that, given my position as the immediate past prosecutor of the ICC, I think that I would just leave it at that.
Thank you. Now, several of our audience members have also asked for your opinion, and you can answer that in your personal opinion now, post-ICC. What are your thoughts about possibly broadening the court's jurisdiction over, for example, the crime of ecocide or the crime of terrorism?
I remember when I took out the policy, the case selection and prioritization policy, I tried to explain how the office of the prosecutor could possibly have jurisdiction. And if you look at the policy, you will see that how maybe because of the crime of ecocide, Rome Statute crimes get committed, or because maybe Rome Statute crimes get committed and affect crimes of the climate. I tried to draw that distinction to also look for ways in which the office could intervene in situations like that. But of course, unfortunately, it was taken out of context. And at the time, there was a lot of debate about saying that, oh, the ICC prosecutor now, without having these provisions under the Rome Statute, is overreaching, is trying to. But this was what I was trying to explain at the time. Because as it is now, as it stands, if you strictly interpret what the Rome Statute says, of course, we will not be able to investigate and prosecute. And I know that there has been some states who were already thinking about some form of a convention that could be used for the prosecution of these kinds of crimes. And I also think that they're very important crimes. They're very, very important given the status of the world today, given the climate change, given the problems that we are all facing. I believe that once we do have those laws and have the authorization, if I may put it that way, or the jurisdiction to be able to investigate and prosecute that, I think that would be a major contribution to climate change itself.
Thank you. The next question has to do with your interactions with the UN Security Council. And again, we all know you made regular appearances, you briefed the Security Council. Many times there were fruitful discussions there, but no action taken in the end to directly support the court. How did you find a way to have fruitful, positive interactions with the Security Council?
I really believe that the relationship between the ICC and the Security Council is very important. It's really particularly important, and I think that for both to have results, for both of them to be effective, the interaction between the ICC and the Security Council should be more regular, and not, for instance, just wait for when the prosecutor has to go and submit a report or a briefing on Libya or on Sudan. I think there are important thematic issues in the world today that the ICC is dealing with, as well as the UN Security Council, that there could be a symbiotic relationship between the two. And when I used to appear before the ICC, before the UN Security Council, I had made various suggestions about how we can really make this relationship work for everybody, by liaising with each other more, by also, and I was very particularly suggesting ways, concrete ways in which we would be able to have that interaction. Of course, you know the situation at the Security Council. You know the fact that 3 out of the 5 permanent members are the ICC member states. No, are the ICC non-member states. Okay. Yes. So, and we know that the Security Council is a political body. And we do know that there are really times in which those who are states parties to the ICC would want to push some agenda forward when others will not allow that to happen. And to a large extent, this kind of created a very difficult relationship between the court and the especially, at least speaking for the Office of the Prosecutor, in terms of these two situations that have been referred to the ICC. You have heard me several times going there to say that we need more than words. We need concrete action to be able to at least do the investigations and prosecutions of what you have referred to us. It is more than just making a referral. It is supporting the court. It is trying to get those who have been indicted by the court arrested and brought to the court. So this relationship continued to be a very difficult one. But I'm glad that before I left, at least a focal point was identified, a focal point that would be between the ICC and the UN Security Council, and be able to perhaps make things more easier to discuss or put it on the table or identify them at least. And I think this was a step, it was a good step for this relationship, because it had gone to a point in which even the letters that were coming from the ICC to the UN Security Council were not addressed. It was just there. And I think that is not a way that as two important bodies, charged with responsibilities of security and justice and accountability should be acting. I think we need to do more and more. We've moved forward a bit, but there's much more needs to be done to have this relationship help in providing efficiency, effectiveness in what we both mandated to do.
Now, the next question, and this is also, I think, really important, has to do with the reparations. And the question goes as follows. The prosecution of gender-based crimes has drawn greater attention to the unique harms women suffer during and after periods of armed conflict. What kind of reparations do you think would better account for women's unique victimization? And should they be driven by states, by external parties? And I would add to this, if you can just more broadly comment on this issue of reparations, because I do know that international tribunals are somewhat limited in providing reparations. So what are your thoughts on that?
Well, you do know that when the ICC was created, of course, the Trust Fund for Victims was also created. And the Trust Fund for Victims is exactly that, to be able to assist, especially those victims of ICC crimes, when there's a conviction, for instance. But also, as you know, there is the not the rehabilitation mandate, but there is this other mandate that the Trust Fund has, that they are able to even help during the time that the cases are ongoing. So this is, I think that one of the setbacks that we had during the ad hoc tribunals was the fact that there was no reparation. There was no reparation, and we have seen several times in which victims of these crimes would say that, I mean, I am the one who suffered for the crimes, but today this perpetrator is being treated for HIV/AIDS, for instance, and I don't have that opportunity. We have seen that in the ad hoc tribunals, at least at the ICTR, we have heard those complaints. And this is one of the main motivations for having an independent institutions like the Trust Fund for Victims, so that when victims, when they are able to, well, not able, but when they exercise this right to participate in proceedings and there are findings made that they are, of course, victims, then the Trust Fund for Victims will be able to eventually come in and assess those, the victimization, and be able to see what is best suited for them in that particular instance. And I must say that the Trust Fund for Victims has been doing quite well in that regard. I believe that they have really done quite well. The most recent one was in Mali, in which one of the last public events that I participated. And as you know, what they do is they make a real assessment of what does this mean for the victim. What would be the most fitting reparation that should be given to this victim? Should be based on community, or should it be individual? And as time went on, I know that they're really evolving more and more in terms of experience of what they have been doing from Central African Republic to Uganda to the Democratic Republic of Congo to Mali. And even recently, I believe that they have been working very, very well in Georgia as well. I remember in the Bemba case, this is just an example. As you know, this is one of the disappointments or the cases that we really, the fact that Bemba was arrested and unanimously convicted, and on appeal, this was reversed by 2 against 1. I don't even know. It's always, but you know, I was able to speak with the leadership of the trust fund, Because the problem that this created was the fact that Central African Republic, as you know, there was the other case again, the Yakatom Gaisona, which now is trying, we were starting investigations. And they were saying, the victims were saying that why should we cooperate with the ICC? Look at what has happened in the Bemba case. After all these years of waiting, the court has come to decide otherwise. They wouldn't even be able to make the distinction with the fact that the office of the prosecutor are the investigators and the prosecutors, and that this is a decision that the judges have decided. For them, it's ICC. So this really created a very huge setback for us. We had to, talk to them and convince them and talk to the leadership and really spend time on it before we were able to gain the trust and confidence again. So I think that in each situation is unique. Each situation is unique, and there must be a proper assessment of what happened, what took place, how was the victimization, what was the scope of the victimization, what do these people need? Because they should not just be seen as victims, but survivors. They need to be able to move on with their lives. And what can you do to assess what really would help them to move forward with their lives? And as I said, I do believe that the Trust Fund for Victims is doing a good job about that.
Now we're nearing the end of our discussion, and I would like to ask you this last question. In your own words, what would you like your ICC legacy to be? What would you like people to take away from your tenure as prosecutor at the ICC? That's an unfair question.
If it would not be too broad, I would say justice and accountability, but I could not narrow it down. I believe that the ICC was set up really after we have witnessed such horrendous wars taking place and so much harm being done to humanity. And the international community came together and said that we need this institution to ensure that there is justice, to ensure there is accountability, to ensure that victims will have a hope. They will have an institution where they can place their hopes, knowing that if the state that I am from will not do anything, I can look to this institution as a beacon of hope. That that this is going to happen, that because the ICC is there and the ICC will take its work seriously, and the ICC will ensure that there is justice for the victims of these crimes and there is accountability. For me, I can say that this was always what was uppermost on my mind. Always, this was what was my driving force, that this institution has to be seen as a credible one, an efficient one that will do its job without fear or favor. This was critically important, I believe, for the credibility of the institution, for people to continue to trust that this institution is here and is doing what it is supposed to do. Of course, I would still highlight the issue of sexual and gender-based crimes. This is really something I want to be remembered for. And also, I did have the policy on children, because I saw women and children as really very vulnerable, especially in times of conflict, and that one should always pay a lot of attention to what happens to them during these conflicts. Before I left, I was looking at the cultural property, which, as you know, is a policy that I took out just before I left. And my next policy was going to be on modern slavery, which I think that we also need to look at very closely and see how we can bring it within the framework of the, it's there anyway, of the Rome Statute. So these are the things really that have been guiding me as a prosecutor of the ICC, which I took with utmost seriousness and did everything that I could to ensure that this expectation that was from everywhere, not just from the victims, but even those who stand up for justice, what they want to see, that's what we did.
Thank you. Unfortunately, we're running out of time. Thank you for joining us, and thank you to our audience members for submitting your questions, and apologies that we did not get to all of them. Time was short. The webinar recording will be available on the PILPG website and shared with all the attendees on Zoom via email. I would like to reiterate that this event was part of the PILPG Thought Leadership Initiative series. Thank you so much, Prosecutor Bensouda, for taking the time today to talk to us and share your legacy with us. We're hugely grateful to you for the work you have done for international criminal justice at the ICC. And I encourage everybody to follow the Thought Leadership Initiative and join us for the next event next Friday on March 4th at 12 noon Eastern Standard Time on the role of international law in the Ukraine-Russia conflict. Have a wonderful rest of the day.
Thank you very much. Thank you for having me. Thank you.
Thank you.